So we now have responses from Taylor Lorenz and Ari Jacob responding to her response to her amended complaint. Let's talk about it on this video. Hello and welcome to my YouTube channel. I go by the name of Dr. Heinz. Thank you so much for tuning in once again. If you're a new subscriber, thank you so much for subscribing onto my channel. Welcome to the crazy world of Dr. Heinz Express. If you are an existing subscriber, do check to see if you're still subscribed, because I've been receiving quite a few mentions saying that YouTube has been unsubscribing people without their knowledge. So do check to see if you're still subscribed, and if you're not subscribed, consider subscribing, because we got a lot of content ready to drop on this channel. So much coming up, especially for December. You don't want to miss out. But also for this video, I am not offering any legal advice in any capacity. I am not a lawyer. I am simply offering my commentary and opinions regarding this case, and this case is extremely interesting. So before we get into the response letters from either side, just a bit of recap. Ari Jacob is suing Taylor Lorenz for her article that she wrote titled "Trying to Make It Big Online, Life Is Not What It Seems." That might not be the accurate title, I'm just paraphrasing, but yeah, she done that piece on the clients that influences, which was Ari Jacob's brand at the time, or Ari Jacob's management company that she was running at the time, and she basically decimated Ari Jacob in that entire article. There was so many allegations being raised, allegations of nudes, allegations of not being able to shower for these clients in these content houses. I've done a thorough breakdown of this, so the title card should appear on your screen so that you can go watch it in your own time. However, because of that article has brought this lawsuit, and the lawsuit had 14 statements that were considered defamatory by Ari Jacob that was brought, and 5 of those statements survive. Statement 3, which was that the Kennedy residents were told that they were going to share a larger share of the rent. The judge found that was defamatory and actionable. That survived. Statement 8, in regards to a promise, I believe it was Singer, don't quote me on it, I'm bad with names really, but she alleged in the article, well, Taylor wrote that she alleged in the article that she was promised brand deals and money, etc., for all these things, and these things never materialized. That was actionable. Statement 9 as well, where it was alleged that security camera was installed without their permission. That was also actionable as well. Statement 12, which was about leaking young nudes of a minor. That was also actionable. And statement 14, this was where it was made false representations about the contract situation regarding Elizona and the mother. I believe it was the mother that was making these allegations. So therefore, that was also actionable. So those 5 statements is basically what Taylor Lorenz is trying to argue to get out completely. And the only reason why this complaint, or the amended complaint, why the complaint was dismissed in the first place, was because it didn't meet or satisfy the actual malice standard that's set by the New York anti-SLAPP law. So because of that, Ari Jacob had to create an amended complaint, because the judge by statute allowed her to amend the complaint before a certain time. Otherwise, the case will be dismissed with prejudice. Sorry. So it was dismissed without prejudice, and after that, Ari Jacob came back with an amended complaint, laid everything out on the table, showed so much proof upon proof. Again, I've done a breakdown series on this. I really recommend that you really go and watch that and get acquainted with the case. But that being said, what Ari Jacob was really alleging was happening, at least what she was trying to infer to be the motive behind Taylor Lorenz's actions, is because of a book deal that she had procured with a business rivals. So therefore, this would be the motivation for the article being created, and why it was so defamatory that it would drive her out of business, because she lost a lot of deals. The damages on this is amounting to 12 million that she's asking for. So the letter that was filed in response to this amended complaint is pretty much what has captured my attention, and I really wanted to see how Taylor Lorenz would actually respond to that entire article. So we're going to go through that and all of that, and just basically lay it out there and see what's going on, and how this may sway the judge and how this may not sway the judge. Quick spoiler alert also, Ari Jacob has responded to the response letter, so we are also going to be covering that as well. Without further ado, let's go right into the response letter. So basically, it starts off with the background saying that we represent Taylor Lorenz, blah blah, and the pre-motion citing that they're allowed to bring this response letter pursuant to the federal rules of civil procedures. They gives it a bit of a background on why the case was brought, and it was brought by Ari Jacob, and this court granted and they have let them know that this court has granted the motion to dismiss. In doing this, the court considered that the law applied, blah blah. I think we have already gone through this a little bit, so I'm just gonna go down to where it gets really spicy. He goes on to say, this court held that amending many of the complaints will be futile because the statements dismissed being true, lacking defamatory meaning, or being hyperbole or opinion, cannot be saved by complaint, if at all, solely for the 5 statements dismissed for lack of actual malice, only if they can plead further information to demonstrate actual malice. So that's why the complaints were dismissed. Like I said, the actual malice couldn't be proven. It's written here again. Having been given an inch, defendants try to steal a mile. Okay, the snarkiness is coming out. Lawyers are instead of abiding by the narrow amendment, the order contemplates plaintiff's SAC, which means second amended complaint, tries not to only resurrect the issues already dispositively laid to rest, but expand the universe of this action. Now, if you read back to the amended complaint, I did get that impression that she was trying to bring the statements back. However, there was nothing in the motion to dismiss that said that she could not argue actual malice, or it was limited to these statements that she had to prove. All the judge was saying, well, in my honest opinion, is that these statements cannot be resurrected at all, and these statements you have to prove actual malice for. That's all he said. He didn't say anything about you cannot refer to these statements in any way because they're dismissed, etc. There is a reason why he said that it cannot be resurrected, because he has the idea that, come on, they're gonna try and use those statements to persuade the judge. At least in my honest opinion, that's what any good lawyer would do, and there's no law really against, in my opinion, I haven't seen the law against arguing for statements that has already been out, but not arguing for them to be resurrected, but just show that there was proof for these statements, that there was this, there was that. That's where I'm coming from. So I haven't really seen that. That's why I thought I'd just put it out there. In particular, the SAC seeks to recover an additional allegedly defamatory statement and adds facts pertaining to dismissed statements. Regarding dismissed statement 5, dismissed statement 6, regarding statement 10, it basically goes on to list of statements. The SAC also maligns Lorenz with allegations entirely unrelated to the article, adds irrelevant allegations complaining about Lorenz's reporting in another article, and traffics in groundless and again irrelevant speculation as to why Lorenz left the Times. The SAC even attempts to dispute this court's decision by contending that California law applies. I may have touched on this. I don't know where that was. I didn't see that in my breakdown. I'm really struggling to see where they're coming from here. I didn't look over my previous breakdown to see if I missed this. I'm just gonna go on a limb and say I probably didn't, because if they're trying to argue California law in their Second Amendment complaint and say that this applies, I maybe if that, I don't know where they got that from. Maybe if it was maybe the commission board that she brought in and say, look, listen, this was what happened, so therefore, you know, this was in the commission board about the water issue. That's all I saw. So I don't know what law they're trying to. I don't know. I haven't seen it. And I would have. I've this one. I don't know. This one is making me think this is a bit It's kind of misrepresenting the facts. But I don't know. I have to look over it again. Finally, the SAC asserts 2 new meritless tort claims for tortious inference with prospective economic advantage and intentional infliction of emotional distress. Defendants respectfully request a conference before the court regarding their anticipated motion to dismiss the SAC. As a threshold matter, the new improper allegations must be dismissed because they are far beyond the scope of tailored amendments permitted by court order Mitchell and Signa Corp. Mitchell and Arms case was cited. I understand why they went here in terms of it being frivolous and beyond the scope of what Mitchell is asking for, in terms of like because he was alleging so many things. And everything that he was trying to build his case on was way overboard, basically. However, what I don't understand is that case and this case cannot. Well, they're not the same. I don't think this case is even frivolous in any way or malicious, because at least Ari Jacob has actually got proof of everything that she's talking about. There is that. Whereas Mitchell didn't really have anything. It was just mainly inferences and whatever he could find to try and bring the case forward. Again, he didn't have anything that was based in law or fact, and he had to be dismissed. So, quoting this case was, I mean, I guess you gotta defend your client the best way possible, and even the amended allegations that are properly before this court, which attempt to plead actual malice for the remaining portions of statement 3, 8, 9, 12, and 14. Should be dismissed because they fail to establish plausible grounds to infer actual malice by alleging enough facts to raise a reasonable expectation that discovery will reveal evidence of actual malice. I actually think they've done enough to show, hey, if we get to discovery, you will see that communication between these guys and between these clients could be deformed. Like, it could actually prove what I'm trying to say. It could actually show that these guys just didn't like me, and they had a cause to go to make this whole hit piece and leave. It's very possible, because from what I've seen so far, especially with the whole Vaynerchuk affiliation. From again, I think I said this in the previous video, where you could see, I think, what's her name, Emily something, forgot her name, Brittany Rawlinson. Where you can see Brittany Rawlinson, I don't know, I butchered her name already, but you can see this girl basically celebrating how she got a spot in Super Bowl, thanking Ari, and then all of a sudden turns around and says all these things and, you know, put it out there about being unpaid and how Gary Vaynerchuk is not even affiliated with her. It's wild to me that would happen, and yet there was this other side, and you don't think that would infer some sort of actual malice? Not that Taylor had to investigate that, but more of, there is more to this case, basically. Plaintiffs' supplemental actual malice allegations fall into 3 categories, each of which, as the court has already held, are unsuccessful, taken on their own or altogether. What I will say this: I don't think when Ari Jacob filed the complaint, I don't think that she thought that she had to provide this much evidence that she did in the amended complaint, because the reaction to getting that other chance is something that if she had brought this to the first complaint, I highly doubt it would have been dismissed. I very doubt it. But based on what she brought in, though, like if she brought that in the first time, I doubt those statements would have been dismissed. I think a couple more may have survived, but I think she would have done enough to infer actual malice. The Barrett and Connor case is actually a very good case to cite. It does say that just because someone's failure to investigate does not actually mean bad faith, and also reliance on anonymous and unreliable sources is actually can infer actual malice. Immediately I'm called back to the declaration by Kai Offers, who actually was an not anonymous but a very unreliable source, especially with their own admission and taking down the article. But the article from Taylor Lorenz is still up. That was heavily influenced by the article by Kyle Offers. Is that enough? Is that enough to infer actual malice? I think it is, based on this case law. I think also if you're looking at this case law as well, even though they quoted it, the judge might just be thinking, especially when you look at sources and if they're reliable or not, you have two train of thought, at least in my own opinion. A biased source is not reliable. Someone who's biased for whatever reason, like a former employee, etc., is not reliable, in my opinion. They have something to gain, and there's also, especially the inference of bias could be enough to show actual malice, because what was the purpose of them approaching you, or you approaching these type of clients? Just these, not the other clients that she was with, because there were other clients that she was actually with that didn't go on to do this hit piece. Cohen was one of them. So what was the bias between these clients and him? So you got to think about those. I mean, at least the judge may be thinking about those things when he's assessing his decision. There's also the other side of the unreliable sources. You could equally argue that the sources are reliable because of just the fact that, well, one, they did work with her, it's eyewitness account. So why would you not trust them? Why would you not call them reliable? There's also that school of thought. So it's a bit, it's a sticky one. So going back to the letter, it says, first, plaintiffs again allege that defendants failed to conduct an adequate investigation, saying Lorenz did not adequately fact check statement 8. Lorenz did not adequately fact check statement 12. But as Supreme Court has held, actual malice is not measured by whether a reasonable, prudent man would have published or would have investigated before publishing, which was the Amant versus Thompson case I was just referring to. So, but in that case, like I said, they have to have the knowledge and the falsity of it before printing. And from what I've seen from Taylor's behavior, I think she knew these things. Like, there's enough evidence here to suggest that she, especially from the pictures that she even posted in the articles that I was covering in the video. Those pictures came from an email, at least. Well, I think they came from an email. But it's enough to show that because the picture is from the email and it's also in the article, you must have got it from there and put it up. It's enough to, for me, it's not looking good, especially with this case law as well. Because if you've seen the falsity and you're like, okay, but then you go ahead and entertain. Anyway, that's what I think anyway. Because he goes on to say, a failure to investigate is not probative of actual malice, since it does not warrant the inference that the times defendants entertain several serious doubts about the truth of the complaint statements. Accordingly, these allegations of supposed failures to investigate cannot show the defendants in reality actually entertain serious doubts about the veracity of statements 8 or 12. I have my doubts. I don't know about entertaining serious doubt. I mean, statement 8. Okay, maybe you can argue that the conversation that maybe you can argue that she didn't know whether it was actually promised or not, so there is no way of finding out. However, for her to go like for statement, I can see maybe statement 8 not maybe surviving. On its face, I think it might survive because alleging something was promised should, give you at least some form of doubt to say, well, did this really happen or anything like that. However, did she, according to that Mount case, did she actually go on to do extra despite that? I think statement 12 on that case alone might be very hard to dismiss the nudes allegation, because the screenshot provided of what Taylor Lorenz done to Reuters, who are known for fact checking, literally says that they done no research. So she was telling other people that they didn't do no research. I did my research, basically. That this person not only scammed people from $10,000 or whatever the amount she said, but also she leaked nudes in retaliation for the client leaving. She is saying that what she's proving here is that, well, I've done my research, I've looked into this, and yes, she leaked those nudes. I know the truth. She leaked those nudes. And what Jacob is basically responding is, no, you don't, because I didn't leak it. This is the actual proof, and this was the discussion with my business partners to prove it. That I didn't even know that these were leaked. I found out from somebody else. What this is showing is, even though you want to argue that she may not have seen it or seen this, or she wasn't even involved in knowing that these photos were leaked, the fact that she went online to actually say what she said and publish these statements online just shows that she acted with reckless disregard. Not knowledge of falsity, just reckless disregard of the truth. She didn't care what the truth was. Not that she had to ask, but if she was to go on and make that statement, it's not looking good. It's not looking good, is what I'm trying to say. So this argument is, just because it says she didn't fact check is not actually a good argument to survive this, to at least get this case, to get this claim, this statement dismissed. Maybe statement 8, maybe I don't know, but not statement 12. I think that ship has sailed completely. Plaintiffs allege that certain information exists in text messages and other documents in the possession of people other than the defendants that rebuts statement 9, 12, and 14. These allegations also fall short of establishing actual malice. The actual malice inquiry focuses on a defendant's subjective knowledge. I don't know about the actual malice like that. I don't think it focuses on the... I don't know. I don't think it focuses on the subjective knowledge. I think that's being misrepresented a little bit. I think, the knowledge of falsity is there as a standard, but there's also the reckless disregard. That's, you may have the knowledge or do not have the knowledge, but the reckless disregard could literally be you, even if you don't know the truth, but you still went on and act like you knew the truth, and act like, how do I act like you? I don't know how to describe it. I don't know how to describe it properly, but the way I interpret how it's broken down, especially the knowledge of falsity and the reckless disregard for the truth, I don't think you have to have knowledge for the reckless disregard bit. I think the reckless bit is just, you just had this allegation, you just heard this, which is where the other case, the Byron Conde case, where it was talking about relying on unreliable sources for your information. So you got the information. However, just because you didn't fact check, if you were to be reckless with that information, that would be inference to actual malice, because you just got the information reckless with it, just went along. You don't have to know if it's false or not. Just the fact that you trusted an unreliable source or an anonymous source and you just went along with it, that's enough to infer actual malice. So that's where I'm coming from in terms of, I don't think it's about just your subjective knowledge alone. Like that, maybe knowledge of falsity, but it's not mapping to me. Without alleging specific facts bearing on a speaker's knowledge, a plaintiff cannot plead actual malice. So even if plaintiffs allege other people knew facts inconsistent with reporting, that knowledge is irrelevant into the actual malice standard unless plaintiffs have also plausibly alleged that defendants knew those facts. And critically, the complaint is devoid of any such. I don't know, man. I don't know. The reckless disregard is an or statement, not an and. I could be chatting so much BS. I probably am. I don't know. Correct me if I'm wrong. Really, I want a lawyer to really correct me on this. But I really think the Charo case does lay it out, and I really think you don't have to have the knowledge of the actual facts in and of itself. I think if you did, you'll fall under the other standard, the other part, which is knowledge of that it was false. But there is this other part, which is the reckless disregard. That's where I'm coming from. I just don't think that's enough here, in my opinion. Third, plaintiffs retread dismissed ground by re-airing allegations of preconceived narrative, and Lorenz alleged economic motive to establish actual malice. This court has already rejected once these allegations, and they are no more persuasive now. I mean, I don't think he was trying to resurrect these claims, but the fact that they say persuasive and quoted the McDougall case, I think that's very. I think that case is important. I'm going to talk about that case later on when I'm going to talk about that case later on. Speculative allegations of predetermined narrative cannot establish actual malice. Newspapers' motive in publishing a story, whether to promote an opponent's candidacy or to increase circulation, cannot provide sufficient basis of actual malice. Now, this case is very interesting because it was about Tucker Carlson and Donald Trump's whole case, and McDougall was basically trying to say because Tucker Carlson was biased towards Trump, so therefore he was going to be he was not going to hear the truth of the other side and blah blah. He was dismissed. He didn't survive. He didn't survive at all. But there was a lot in that case that I'm going to discuss later on. Even taken together, these allegations do not plausibly allege actual malice. The plaintiff similarly alleged that the Times acted with actual malice based on the list of factors most identical to those at issue here. The Brimlow court considered these factors and concluded that they did not add up to actual malice, ultimately deciding that there was no combinations of allegations from which one could plausibly infer that the Times was purposely avoiding the truth in its reporting. The argument failed here as well. I don't know about that. If you're going to make the claim that Statement 9, especially in Statement 9, that says that they didn't sign consent forms for the consent waivers for the cameras, and there was no consent for the installation of these cameras, and the Times signed this and knew that the cameras existed and still published it, I think that's enough to really infer actual malice here. This is the Amant case the Amant versus Thompson case that I was talking about earlier. There is enough. So far, from the arguments that they've presented, Statement 9, Statement 12 are most likely going to survive. I don't know how you can argue out of we've signed the waiver ourselves, but we're going to publish that they didn't sign a waiver. And it's pretty standard in the industry. It's going to be very hard. It's going to be very hard. It's not impossible, but it's going to be very hard. Finally, the new claims for tortious inference and intentional infliction of emotional distress must fail because, among other reasons, they are wholly duplicative of plaintiff's defamation claims, dismissing redundant tort claims because they are flowed from the effect of the plaintiff's reputation caused by allegedly defamatory statements. For these reasons, respectfully request a pre-motion conference to discuss motion to dismiss. I don't know. I'm reading all of that and I'm just thinking in my head, like, you haven't really, I mean, you've made a good argument for statement 8 being dismissed. You made a good argument for the other claim in regards, the other gist or inference of Taylor Lorenz going for the book deal to be disregarded. I think those are good arguments for it. Whether it will work, I doubt it. Let's go on and see what the response was from Ari Jacob to Taylor Lorenz. We know about the background, we know about all of that, who brought the case, blah, blah, we know. Let's go. To address the court's concern regarding actual malice, the SAC contains dozens of malice-related allegations, including facts pertaining uniquely to each of the 6 defamatory statements, as well as facts that shed light defendants' animus against plaintiffs and willful ignorance of contradictory facts more generally. Before I continue further, I just realized that they did add a 6th and one additional statement into the claim. I just thought I'd go back and read that because they have actually added a new claim into it. I think we're going to find out as we read this letter. Go on and say these additions are amply sufficient to raise reasonable expectation that discovery will reveal evidence of actual malice. This is all the anti-slap is. It's just to show whether you have enough case that actual malice can be proven during trial. That's all it is. Because without the anti-slap and you go to trial, you have to prove actual malice anyway. You have to prove it with clear and convincing evidence. So if you can't even infer that there is some kind of activity here, it'll be kicked out. Defendants' failure to contend with these allegations renders their proposed motion futile. A non-exhaustive description of actual malice allegations plaintiffs have added to this SAC below as follows. I do think they didn't make good arguments. I actually agree with them on this one. I don't think these were good arguments. I think the only one that could get struck out is the rent. Maybe the rent and maybe the promise. Even I'm 50-50 on the promise, but I do see 4 statements surviving. I do see the nudes surviving, definitely. I do see the permission, asking permission. They didn't even argue that one too tough. They just bunched it together and try to say that this whole should be dismissed for this reason. But it didn't target the false representation that was made in regards to whether they had a contract or not. So going back to the response letter, it says, first, defendants falsely asserted that Jacob told Kids Next Door K&D residents that they would have to cover a larger share of the rent. Yet plaintiffs' allegations established that the contractual rent owed by the influencers never changed, and the plaintiffs corrected defendants on this point on 3 separate occasions pre-publication, showing they willfully ignored contradictory information. I think you receiving information contrary to otherwise must, like, you can't read someone's mind. That's fact. You can't read someone's mind, but surely it should give doubts to what is being, especially coming from a source that isn't yours. A source that's different to yours, and from the person that you're writing about. Surely this should give some form of doubt. She didn't go out searching for this information, by the way. She didn't do her research. It's given to her. I think the statement will survive. Second, defendants falsely asserted that Jacobs promised Tiana Singer and rest of the girls in the valley, GIV, brand deals, money, and opportunities that never materializes. Plaintiffs' allegations established that although plaintiffs never managed Singer, defendants carefully passed their words to give readers the false impression that Singer was yet another client affected by plaintiff's alleged lies. Moreover, defendants knew that Jacob did not offer opportunities to Singer. Indeed, Jacob told Lorenz about a big opportunity for the influencers, Playlist Live, and shared details with Lorenz about a trip Singer and dozens of influencers were set to take to the Playlist Live, to the Playlist Creator Conference. A trip influences organized with a sponsorship from a brand deal. Another Lorenz article, the Times published in May 2020, reflects defendants' knowledge of opportunities that plaintiffs had made available to GIV influencers. Another article that shows your state of mind that you do know about this information. There must be, like the Aman case, there must be evidence that even with this knowledge of falsification, or in this case, the lie that was being written, even with that knowledge, that they entertained it, gave it attention to it. I think this satisfies it here. Taylor Lorenz clearly gave attention to this entire debacle in a previous article. I think that's enough. I think that's enough evidence to actually show, yeah, she knew about it, and she still wrote this. So this statement could survive. Third, defendants misled their readers by reporting that Jacob installed a camera in the kitchen of the GIV house without residents' consent. The SEC explains that everyone who entered the GIV house has signed a release and waiver noting the existence of video surveillance when they signed in on an iPad. And it was well known in the content creator industry, including by the defendants, that this was common practice at collaboration houses. Further, the Times knew that Jacob disclosed the existence of video surveillance to entrants of our content creation houses. As a reporter from the Times had visited the K&D house in May 2020, so they got the date, and inquired about signing on the. This will forever be legendary because I've never seen an on goal like this. This is the funniest on goal I've seen in my life. Funniest. I still can't believe you as a paper could do that and still publish it. Like, I'm sorry, but this is enough. I don't know how you can argue around this. There is nothing here that says this is frivolous. There's nothing here that even satisfies the previous case order that I would bring up. The only case order I gave, is the Barrow Conde case that is just not enough to research, because they obviously did say they didn't fact check. But the rebuttal is apt as well, because just because they said you didn't fact check doesn't mean the evidence wasn't presented to you. That was the rebuttal here. Don't know, man. Fourth, defendants falsely accused Jacob of leaking nude photographs of Davion Young for her business partners. Yet, defendants were aware that Jacob only learned of the photos after they had already been circulating online, and immediately taken action and had treated the disclosure as a matter of pressing ethical concern. I don't think. I mean, there was secrecy online, sure, but I don't think the defendants knew about it. I still think this will survive, but I don't think this is I don't think they have proven here that Taylor knew about these photos or knew about the information that Jacob had no idea. However, like I said, just the tweet alone about her doing what she did is reckless disregard. It's reckless. It is. You can't just go online on something that you haven't even verified and you just go on and say that. I can't see her escaping this one. I just can't. It's really bad that she took ownership of nearly everything that she just said. What I'm trying to say is the evidence that's been presented about Young puts his credibility under check. And can he be reliable to the judge and say this was a reliable source, especially when there's this information? Surely not, because it's not the first time, especially with the added declaration of Kyle offers. It's not the first time Taylor Lorenz has actually engaged working with unreliable sources, just like the Barrow case, as laid out. It's going to be very hard to see. I don't see it. I just don't see this claim being dismissed. I would be very surprised, extremely surprised, if it is dismissed. I would be surprised, but I think it's very strong. Even though it hasn't proven Taylor Lorenz seeing it or doing anything like that, this is purely reckless disregard. Fifth, the defendants reported that Jacob made false statements about representing Elizela, and that Jacob added Zela's name and photograph to influence his marketing deck without Zela's mother's permission. Yet, Jacob informed Lorenz pre-publication that Zela was no longer involved in the GIV project. Remember this, in the GIV project, and offered to put Lorenz in touch with Zela's mother. Oh wow! Knowledge of falsity. Went ahead and done whatever she wanted to do anyway. 6. Defendants defamed plaintiffs by stating that the water and electricity in the GIV house went off in April 2020, yet defendants had ready access to information showing this was impossible, as the California Public Utilities Commission was enforcing a moratorium on utility shutoffs during this time. I don't know what a moratorium is. Let me look that up. Let me be a nerd for a minute and look it up. Moratorium means a temporary prohibition of an activity. So it was only withheld for a bit. It wasn't something that was going to be ongoing. They disclaimed this. They said it was going to happen, and it was quite public knowledge. So it's not looking good. And this statement wasn't in the previous complaint, but it could be added. It is an amended complaint. There's nothing in the motion to dismiss to say that you can't add other defamatory statements. There it is. We went through the first complaint. We went through all this. It's not there. Nothing there. The judge didn't say anything of the sort. Further, plaintiffs not only allege facts showing that defendants recklessly or intentionally published the 6 defamatory statements, but also alleged a host of facts evincing defendants' malicious intent with respect to the article as a whole. Defendants ignore the existence of whether former and then argue incorrectly that the latter cannot amount to actual malice. When actual malice is in making a defamatory statement is at issue, the critical question is the state of mind of those responsible for the publication. This is probably why they said that it's a subjective matter, but there is a state of mind application as well as the Palin case. It is Lorenz's state of mind as the author of the article that it is relevant. Actual malice can be established through the defendant's own actions or statements, the dubious nature of her sources, and inherent probability of story, among other circumstantial evidence. The Charo case is actually a very good breakdown. The Chell v. Filipino rep case. I think that case is very important for this case in regards to the fact that there were so many libels being printed out by the defendants, and that case was so weird as well in its findings. But the main idea was the actions of the defendants is the precise reason why that case remains precedent. So it's not just by what you say or what you were thinking, etc. Your actions play a part, which is the reckless disregard part, which is what I was trying to articulate earlier. Personal biases can support finding actual malice where there are facts showing the speaker acted pursuant to the bias. The McDougal versus Fox News case has been cited by both sides, and it is a point of contention in the sense that I think this one might lean more in favor with Lorenz. However, even though it's a case that lost and McDougal could not prove actual malice just based on political bias, it made it clear in that case that because of the Palin case, that you can't just allege political bias or personal bias. You have to have evidence to debunk the claims. So it wasn't frivolous for McDougal. He was frivolous, but it wasn't a loser argument to argue personal biases. That's what they're citing here. So even though it's a case that lost, from my understanding, they're basically citing that despite that being the case, despite McDougal losing, despite all of that happening, remember I cited Palin. The Palin case also appears here. And the Palin case and what was used to rule in the McDougal case was that the political bias that you are presenting here, McDougal, is not enough. You got to show evidence to debunk these claims. And what Ari has done here is she has not just shown the bias. Like Taylor just wasn't biased, but she was also provided evidence of the falsity of these claims. She was also not just provided evidence of the falsity of these claims, but the court has been provided evidence of the falsity of these claims. This case in a way helps them a lot because Palin did beat anti-SLAPP based on this reasoning. So the personal bias aspect, I can see it surviving I can see the claim of having the book deal surviving based on this case. I can see that claim surviving now. Simply because of the fact that there is enough evidence to debunk that these guys were lying, the sources were unreliable. There's enough evidence to show that Lorenz was lying through, that she was reckless with her lies. She was reckless in even publishing this. Even if she didn't have the knowledge, she still went off brazenly, and she has an history of it. And she wrote other articles to even corroborate what the plaintiffs are saying. So it's going to be, I don't see her surviving this. I don't see this surviving based on these arguments. It goes on to say the court can infer actual malice, where the drafting and the editorial process of the statements in question permits an inference of deliberate or reckless falsification. The article is replete with instances in which defendants bent or ignored the truth in order to smear plaintiffs. But for a few examples, Lorenz intentionally misrepresented the relationship between plaintiffs and Gary Vaynerchuk to make plaintiffs seem dishonest. Mention a California Labor Commission complaint against Jacob, but intentionally left out the fact that Jacob had not violated the labor law at issue. I think it's a good, even though it's a dead claim, I think it's enough to just infer actual malice. Maybe not for the individual 5 statements, but for the article as a whole. They were never going to win the Vaynerchuk thing. But the same way that I was screaming that the judge should have separated this, it's the same way that you can look on the way I was screaming in the previous in the breakdowns that there were some statements that the judge should have separated, like the labor law issue and the rent payments. I think he should have separated that. But equally, I think the way that is being framed, I think it's enough to show actual malice here, and the judge should be able to see how these are tied together and not really treat it as a separate issue, even though you can't resurrect those claims. I think it's enough to show that if this goes to discovery, that you have enough to actually prove with a preponderance of evidence that actual malice is actually here. California Labor Law Commission complaint against Jacob, but intentionally left out the fact that Jacob had not violated the labor law at issue. Implied that plaintiffs were people who exploited child internet stars in a post-shady behavior, pressured and lied to sources, and misquoted the source on Twitter to make it seem like the source was criticizing Jacob rather than the history industry as a whole. That's the screenshot I believe I showed earlier regarding Reuters. In addition to whatever personal grievances Lorenz harbored against the plaintiffs, Lorenz also stood to profit from her hit piece as a result of her business relationship with plaintiff's competitor, as a talent agency. This is the personal bias playing in. I think this is a strong case. for the personal bias, because she has provided claims to debunk the claims and shows personal bias. So I think, based on the Palin case, it should survive. As alleged in the SAC, Lorenz's familiarity with the influencer industry, having authored a book on the subject, render it wholly plausible that Lorenz's errors about the basic facts regarding the industry stem from actual malice and not mere incompetence. Lorenz, not mere incompetence. Oh, you gotta hold that L right there. You gotta hold that L. So you could also basically saying, Taylor, you can argue that you were incompetent in your reporting, but this is more. That's basically what it's saying. Lorenz's reporting practices, including not giving Jacob enough time to provide factual content for the article, refusing to consider critical documents that would refute the narrative Lorenz was advancing, and publishing information she knew to be contradicted by information available to Lorenz, including information on social media accounts of influencers she followed, or provided further evidence of defendant's actual malice. I think this is a fair argument. I don't think the judge is gonna buy, because he didn't buy it the first time. I don't think he's gonna buy that he should be given enough time. I think he could persuade him, but I don't think he's gonna buy it. I don't think he's gonna rule and say, yeah, he should have given you enough time. I think he's gonna stick to his word, saying the time is not the issue. However, you have proven your case. Plaintiffs have therefore buttressed their allegations specific to each of the 6 defamatory statements, with allegations showing that the defendants deliberately engaged in shoddy reporting practices to produce an article rife with falsehoods to carry out their animus against plaintiffs. Defendants try to wave away plaintiffs' claims of tortious inference with prospective economic advantage and intentional infliction of emotional distress by arguing that they are duplicative of plaintiffs' defamation claim. Not so. Plaintiffs alleged that influencers breached their contracts with plaintiffs because of their interactions with Lorenz, or because of pressure from others involved in these interactions. Plaintiffs further alleged that Lorenz doxed plaintiffs by disclosing the address of the KND house, despite promising that such information was not for publication when soliciting it from Jacob. I think that's enough. I think that's enough to show personal bias, malice, not actual malice, but just malice, because you have. I'm not gonna repeat my run through is right there, but I think that's enough. Plaintiffs therefore respectfully submit that the court should reject the defendant's request for pre-motion conference, deny defendants leave to file a motion to dismiss, and allow the case to proceed. I think this is a very strong case. I don't know how the judge is going to rule this one. In my honest opinion, I think there is a very strong likelihood that, like I said, 4 statements, 5 in this case, adding the extra statement has been added. Let me stick with 4. I think the Labor Commission one, the California Labor Commission Board may survive, may not. But I do think the other 4 statements, the nude, the promise, not the promise, the Zona, the signing of the that's definitely not getting dismissed. That's definitely not getting dismissed. I think those statements are going to survive. I think this is a winnable case. I think the evidence shown so far, you would be mad not to at least take one statement. The judge, I think, is going to rule in favor of the plaintiffs. I could be wrong. I may not know what I'm talking about. Whatever you might want to say, but it is a very strong case. It is a very strong case. I think Taylor Lorenz really buried herself on this one. Thank you so much for tuning in and watching this video. I really do appreciate each and every one of you that do tune in and watch, like the video, comment in the comment section. You guys are amazing. I've got plenty more videos coming up in the future. I am currently working on a project that I want to release by the new year. and I will try my best to also cover the Courtney Claney case. That is my next case that I want to cover before the trial begins, before jury. I do want to live stream that as well if possible. But yeah, that's what I'm working on so far. Thank you so much again for tuning in. I hope you enjoyed the video. If you like it, even if you didn't like it, I appreciate you giving me your time and lending me your ears. I'll see you on the next one. Have a good evening. Take care of yourselves. Stay blessed.